Revocable versus irrevocable trusts. How to decide which is right for your Illinois estate. If you're choosing between a revocable trust and an irrevocable trust in Illinois, the right answer depends on whether you want flexibility or protection. Both trust types can support estate planning, but they work very differently and serve different purposes. A revocable trust gives you control during your lifetime, while an irrevocable trust may offer asset protection and potential tax benefits if structured correctly. The choice comes down to your goals and how much control you are willing to give up. A revocable trust is a legal arrangement that you can change or cancel at any time during your lifetime. You transfer ownership of assets into the trust, but you keep complete control as the trustee. Because you retain control, the assets generally remain part of your personal estate for tax and creditor purposes. Under the Illinois Trust Code, a revocable trust can generally be amended or revoked during your lifetime as the document allows, or through a later signed writing that specifically refers to the trust. Many people use a revocable trust to avoid probate, maintain privacy, and manage assets if they become incapacitated. A key point is that a revocable trust gives you flexibility, but it does not protect assets from creditors or reduce estate taxes. An irrevocable trust is generally permanent once signed and funded, and you typically give up control of the assets to a separate trustee who manages them under the trust terms. In limited situations, Illinois law may allow modifications, sometimes through a court petition or a valid non-judicial settlement agreement. Because you do not retain ownership and control, a properly drafted irrevocable trust can reduce your taxable estate. Creditor protection is not automatic in Illinois, and if the trust can make distributions to you, creditors may be able to reach the maximum amount the trustee could distribute to or for your benefit. The trustee must also follow the trust terms and comply with Illinois duties, including notice and accounting requirements. People often use irrevocable trusts for estate tax planning, asset protection from lawsuits, and Medicaid long-term care planning. In Illinois, control is one of the biggest differences between these trusts. With a revocable trust, you keep full control, and you can change or cancel it. With an irrevocable trust, you generally give up control, and changes can be difficult without legal mechanisms like a court order or a valid non-judicial settlement agreement depending on the issue. A revocable trust does not provide creditor protection because you still control the assets. An irrevocable trust can offer stronger protection if drafted correctly, but trust terms matter if you may receive distributions. Tax treatment is also different. Revocable trusts generally do not provide tax benefits during your lifetime or at death, and trust income is typically treated as your personal income. When you pass away, assets in your revocable trust are included in your taxable estate. Irrevocable trusts may reduce what is counted in your taxable estate if structured correctly and you do not retain certain powers or benefits. This can matter in Illinois because the estate tax exclusion amount is $4 million for deaths on or after January 1, 2013. Income tax treatment depends on the trust, because some irrevocable trusts are grantor trusts while others pay tax at the trust level or pass income to beneficiaries. Medicaid planning requires extra care. Transfers to an irrevocable trust can trigger a Medicaid penalty if made within the 60-month look-back period. In Illinois, if an irrevocable trust allows withdrawals or distributions for your benefit, Medicaid may treat the trust assets as available, so the trust terms must be drafted carefully. A revocable trust may be right if your main goals are flexibility, probate avoidance, privacy, and incapacity planning. It can also help if you own property in more than one state, because it may reduce the need for multiple probate proceedings. An irrevocable trust may make sense if asset protection, Medicaid planning, or Illinois estate tax reduction are priorities, and you are willing to give up control to pursue those benefits. Your estate value relative to the Illinois $4 million estate tax threshold can help guide whether more complex planning is worth discussing. Many comprehensive plans use both types, with a revocable trust as the core plan and one or more irrevocable trusts to target specific goals like tax reduction or stronger protection. Coordinating trusts requires correct asset titling, aligned beneficiary designations, and documents that work together rather than creating confusion later. A lawyer can explain how Illinois rules on control, creditor exposure, and administration affect the outcome you want. An attorney can also help you weigh flexibility versus protection before you transfer assets and lock in long-term consequences. Illinois estate law offers guidance on revocable and irrevocable trust planning, including how tax and Medicaid considerations can change the best approach. This law firm also serves clients throughout Chicago and Illinois with flat-fee pricing and virtual consultations. Working with the right law firm can help you choose a trust strategy that protects your assets, minimizes taxes where possible, and supports your family's needs. A lawyer should ensure the trust terms match your goals and do not create avoidable risks for taxes, creditors, or Medicaid eligibility. An attorney should also confirm the plan is coordinated so your documents and beneficiary designations align. Illinois estate law can help you decide whether a revocable trust or an irrevocable trust fits your Illinois estate planning goals, and you can reach the firm at 312-373-0731 or visit 4422 North Ravenswood Avenue, Suite 212, Chicago, Illinois, 60640, United States.